All rise.
Judgment in the appeal, the Queen on the application of Barclay and others against the Secretary of State for Justice and others.
Lord Collins will deliver the judgment.
Sark is an island in the Channel Islands with about 600 inhabitants. In this appeal, Sir David and Sir Frederick Barclay sought to challenge new constitutional arrangements in Sark contained in the Sark Reform Law of 2008. Under the Reform Law, the electorate of about 500 people vote for 28 members of Sark's legislature, which is called the Chief Pleas. But there are 2 members of the Chief Pleas who are not elected. The first is the Seigneur, or Lord of Sark, who holds a title first granted by Queen Elizabeth I in the 16th century. Under the Reform Law, although he may speak at meetings of the Chief Pleas, the Seigneur cannot vote, but he does have a power temporarily to veto ordinances of the Chief Pleas. The second person is the Seneschal, or Steward, whose office was created by the Crown in the 17th century. The Seneschal convenes meetings of and presides over the Chief Pleas, but he has no power to speak in debates or to vote. But historically, both the Seigneur and the Seneschal were able to vote in the Chief Pleas. On this appeal from a majority judgment of the Court of Appeal, the Barclay brothers argued that the position of the Seigneur and the Seneschal under the new arrangements was incompatible with Article 3 of the First Protocol to the European Convention on Human Rights, which protects, and I quote, the free expression of the opinion of the people in the choice of the legislature, end of quotation. They argued that the effect of that provision is that all members of a single-chamber legislature must be elected members. An appeal was also brought by Dr. Thomas Slivnik, who wanted to stand for election to the Chief Pleas. He argued that the Reform Law discriminated against him contrary to the European Convention. He said that this was because, even though he had a right to vote as a resident of Sark, he nevertheless did not have a right to stand for election, as he was a citizen of Slovenia. The Supreme Court holds that the unelected position of the Seigneur and the Seneschal in the Chief Pleas is not incompatible with Article 3 of the First Protocol to the European Convention on Human Rights. It holds also that the restriction on Dr. Slivnik standing for election is compatible with the Human Rights Convention. The appeals are therefore dismissed.
Judgment in the appeal, I, a child.
The judgment of the court will be delivered by Lady Hale.
This appeal concerns whether an English court has jurisdiction to determine the future level of contact between a child and his mother, where the child does not habitually reside in a European Union member state. Under Article 12.3 of Council Regulation number 2201/2003, usually known as Brussels II Revised Regulation, parties are able to opt in to the jurisdiction of an EU court, which would not otherwise have jurisdiction to determine a child's future. This applies where, firstly, the child has a substantial connection with that member state, and secondly, the jurisdiction of the courts of that state has been expressly accepted or otherwise in an unequivocal manner by all the parties to the proceedings at the time the court is seized, and that the exercise of the jurisdiction is in the best interests of the child. In this particular case, the child had been resident in Pakistan since 2004, although both he and his divorced parents are British citizens and his parents live here. The High Court and the Court of Appeal held that the English court had no jurisdiction and that therefore there was nothing that could be done. Both the mother appealed to the Supreme Court. The Supreme Court had 2 issues to decide. The first was whether Article 12 did extend to cases where a child lived in a non-EU member state. The Supreme Court decides that it does. The second issue was in that event, whether the parties in this case had indeed accepted jurisdiction in accordance with the criteria set out in the article. The Supreme Court decides that in this case they had done so, not least because the father had given an undertaking to the English court to return the child to this jurisdiction when ordered by an English court to do so. The appeal is therefore allowed.
Judgment in the appeal, Secretary of State for Environment, Food and Rural Affairs against Meyer and another.
Lord Roger will deliver the judgment.
A number of travellers established an unauthorised camp in Hethfelton, one of the woods in Dorset, owned by the Secretary of State for Environment, Food and Rural Affairs. The Secretary of State sought an order for possession in respect of Hethfelton and other specified woods which had not yet been occupied by the defendants. The Secretary of State also sought an injunction restraining them from re-entering Hethfelton and from entering the other woods. The Court of Appeal granted an order for possession in relation to both Hethfelton and the other woods. By a majority, they also granted an injunction against the defendants occupying the other woods. The defendants appealed. The Supreme Court unanimously allows the defendants' appeal to the extent of setting aside the wider possession order made by the Court of Appeal, but dismisses the appeal against the injunction. The majority holds that a court cannot grant an order for recovery of possession against defendants who are not actually in possession of the other woods. Lady Hale would favour a wider possession order that was tailored against known individuals who had already intruded upon the claimant's land, were threatening to do so again, and had been given a proper opportunity to contest the order. The Court considers that the Court of Appeal was right to hold that it was appropriate to grant an injunction against the defendants occupying the other woods. The Court observes that there may be reasons to consider reform of the remedies in this area of the law.
The Court will now adjourn.